Hello and welcome to Law Minds. In this video, I'll be discussing the concept of admissions under the Indian Evidence Act 1872. The Indian Evidence Act intricately governs the admissibility and treatment of evidence in judicial proceedings. Among the various facets of evidence, the concept of admissions holds a significant role, serving as a gateway to understanding the complexities inherent in legal testimonies. In this video, we will go through the nuanced provisions of the Indian Evidence Act to decipher the multifaceted concept of admissions. Admission in legal terms includes any statement, whether oral or documented, that implies an inference regarding a pertinent fact in a legal case. Within the legal context, admission stands as an important form of evidence capable of excusing the need for additional proof of the admitted fact. Nevertheless, not all the admissions find admissibility in a court of law. The Indian Evidence Act sets forth specific conditions and principles that regulate the admissibility and evidentiary value of admissions. Let us first understand the definition of admission. Admission in a legal context are statements expressing an individual's perspective on a fact in question or a pertinent fact within a case. These statements may take oral, documentary, or electronic forms. Although considered primary evidence, admissions are not conclusive proof but play a crucial role in establishing or challenging disputed facts. The Indian Evidence Act thoroughly defines and regulates the admissibility of admissions in sections 17 to 31. According to section 17, admissions can be made by various individuals or under specific conditions, including parties to the suit, their agents, representatives, people with a vested interest, those from whom interest is derived, and individuals referenced for information. The admissibility and evidentiary value of admissions depend on factors like the statement's nature, the identity of the speaker, the recipient, timing, location, surrounding the circumstance, and the intended purpose. The key principles surrounding admissions include their relevance and admissibility against the maker or the representative in interest, with exceptions for certain scenarios. Admissions, while not providing conclusive proof, may operate as estoppel under specific conditions. They can be substantiated through oral, documentary, or electronic evidence. The originator or the representative can contest or clarify admissions, demonstrating factors like mistake, lack of intent as admissions, a different context, qualification, retraction, irrelevance, or inducement. Moreover, admissions may be waived or abandoned by the originator or the representative, showcasing factors like non-reliance, superseding events, revocation through notice, or renunciation through subsequent declaration or conduct. In a sense, understanding the nuances of admissions involve considering their multifaceted nature and the principles outlined under the Indian Evidence Act of 1872. Let's now come to Section 19 of the Indian Evidence Act. Section 19 addresses the admissibility of statements made by individuals whose positions or liabilities require verification in relation to a party involved in a legal proceeding. These statements, categorized as admissions, are relevant against individuals making them during their tenure in a specific position or bearing a particular liability. For instance, if A sues B for not collecting rent from C and C acknowledges owing rent to A, it becomes an admission by C relevant against B. The primary purpose of Section 19 is to allow the admission of statements from individuals not party to the suit, but whose positions and liabilities are pertinent to the matters in dispute. Such statements, while not conclusive proof, can corroborate or contradict other evidence. This section emphasizes that these statements should be made in good faith, without undue influence or coercion, ensuring reliability and fairness in the legal context. Section 20 of the Indian Evidence Act addresses admissions made by individuals explicitly referred to by a party in a legal proceeding. Statements made by a person to whom a party directs for information on a disputed matter are considered admissions. This section is based on the principle that when a party directs another person for information, they implicitly acknowledge the authority and knowledge of that person on the subject. For instance, if A sues B for breach of contract and B directs A to consult C, stating, "Go and ask C, he knows all about it," C's statement becomes an admission by B. Similarly, in a defamation case, if A sues B and B advises A to read a newspaper for the truth, the newspaper report becomes an admission by B. However, Section 20 has its limitations. The person referred to must be a third party, not a party to the suit or their agent. The reference must be explicit, pertaining to the matter in dispute, and it must be made before the suit is initiated. Let's now understand the concept of burden of proof in admissions under the Indian Evidence Act. It determines the party responsible for proving or disproving a fact in a legal proceeding. As per Section 101 of the Indian Evidence Act, the burden lies with the party asserting a fact unless specified otherwise by law. Admissions, whether oral or documented, suggest an inference about a fact and are made under certain conditions outlined in Section 18 to 20 of the Indian Evidence Act. While they are not conclusive proof, admissions can operate as estoppel, preventing denial, which is mentioned under Section 31 of the Indian Evidence Act. The general rule maintains the burden to prove with the party asserting a fact, but this rule has some exceptions, which include: if a party challenges its own admission, the burden to prove the admission's error lies with that party, requiring proper evidence. When relying on an admission made by the opposing party, the burden of proving its truth falls on the relying party. If a party admits a fact relevant to the other party's case, the burden of proof shifts to the party making the admission. The burden of proof in admissions depends on the admission's nature and circumstances. The court exercises discretion in evaluating the weight and value, deciding whether it suffices or requires additional evidence. Let's now discuss Sections 21 to 23 of the Indian Evidence Act. These sections govern the proof and significance of admissions in both civil and criminal cases. Section 20 of the Indian Evidence Act states that admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest except in the following cases. Number 1, an admission may be proved by or on behalf of the person making it when it is of such a nature that if the person making it were dead, it would be relevant as between third persons under Section 32 of the Indian Evidence Act. Number 2, an admission may be proved by or on behalf of the person making it when it consists of a statement of the existence of any state of mind or body, relevant or in issue, made at or about the time when such state of mind or body existed, and is accompanied by conduct rendering its falsehood improbable. Number 3, an admission may be proved by or on behalf of the person making it if it is relevant otherwise than as an admission. This section further clarifies that admissions are relevant and may be proved as against the person who makes them or his representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest except in cases as mentioned before. Section 22 of the Indian Evidence Act states that oral admissions as to the contents of a document are not relevant unless the party opposing to prove them shows that he is entitled to give secondary evidence to the contents of such document under the rules hereinafter contained, or unless the genuineness of a document produced is in question. Section 22A of the Indian Evidence Act states that oral admissions as to the contents of electronic records are not relevant unless the genuineness of the electronic record produced is in question. Section 23 talks about admissions in civil cases. In civil cases, no admission is relevant if it is made under conditions barring its presentation or under circumstances suggesting a mutual agreement between parties to exclude the evidence of it. Coming to the effect of admissions, Section 31 of the Indian Evidence Act addresses the effect of admissions, clarifying that they do not serve as conclusive proof, but may operate as estoppels under subsequent provisions in the Act. The section ascribes evidentiary value to admissions found in sections 17 to 30 of the Indian Evidence Act. Estoppel, a legal principle, prohibits a person from denying a previously made statement's truth. It acts as a barrier to introducing evidence contradicting the fact established by the admission, except in cases of fraud or collusion. The doctrine of estoppel is based on principles of equity, justice, and good conscience. For Section 31 to apply, certain conditions have to be met. Number one, there must be a defined admission as per Section 17. Number two, it must be made by a party or their agent. Number three, a person interested in the subject matter should make it. Number four, it must be made by someone from whom the party derives interest. And number five, it must be from a person referred to by the party for information. The admission must be relevant, clear, unambiguous, consistent, and should not be made under inducement, threat, promise, or deception. Some examples where admissions operate as estoppels include admission of liability in contracts or torts, the existence of a partnership or trust, the validity of a will or deed, title or possession of property, and the identity or relationship of a person. To sum up, admissions within the legal context denote statements articulated by a party or an involved individual that carry an inference pertaining to a fact in question or a relevant fact. These statements, whether presented orally or in documentary form or electronically, are deemed relevant and admissible as evidence under the purview of the Indian Evidence Act 1872. The admissibility of admissions is subject to specific conditions and exceptions outlined in the video itself. Admissions, while not constituting conclusive proof of the admitted facts, play a crucial role in supporting and contradicting other evidentiary elements. The person making admissions or their authorized agent can express these statements in various formats. Importantly, individuals making admissions retain the prerogative to elucidate or retract them, demonstrating circumstances such as mistake, fraud, coercion, or undue influence under which the admissions were made. In both civil and criminal proceedings, admissions serve as a substantial source of evidence, helping the pursuit of truth in the middle of a legal dispute. Nonetheless, a cautious approach is important in their utilization, recognizing the potential for admissions to be open to misuse or manipulation by involved parties or witnesses. As a result, the courts have to carefully and thoroughly review admissions to decide if they can be used as evidence. They have to look at the statements together with all the other evidence that is specific to each case. That will be it for the video. Thank you.